Afternoon, folks. Let me say thank you for the patience that you've shown during this rather extensive jury selection process, which is now complete. Gina, please show on the record that all the 12 original jurors and the 3 alternate
Afternoon,
jurors
folks.
are
Let me,
now present in the courtroom and now seated in the jury box. So thank you for the patience that you've shown during this rather extensive. A notepad and a pen and a badge. I know you're on the jury, but we want everybody else to know you're on the jury too. So if you would throughout the course of this trial, wear that red badge that shows that you're a juror whenever you're out and about, whether you're out to lunch or on the elevator or in the lobby or anywhere. That way, people will know that you're not here as just a member of the public today. You have a much more important role, and they will be careful not to talk around you and innocently say something or say something to somebody else in your presence on the elevator or otherwise that might influence your verdict or question your integrity. So that's just your notice to the world that you're a juror, and for the rest of the world to be careful what they say and do around you. And if you would do that, please. If you misplace your badge, let us know. That both will find you one. Please, if you'll wear those, it will be helpful to you and to us while you're here. Madam Clerk, can you please impanel the jury?
Ladies and gentlemen of the jury, you are duly sworn and are now impaneled to hear the evidence when the state of North Carolina versus Amanda Hayes. Sit together, hear the evidence, and render your verdict accordingly.
Ladies and gentlemen, that's the technical way we begin the lawsuit. As the clerk has said, you've been sworn, you're now impaneled to try the issues in the case. You'll sit together, hear the evidence, and render your verdict accordingly, according to the evidence as you find it to be true, and according to the rules of law that I'll explain to you in great detail at the end of this trial. You must be at all times fair, objective, and impartial. You can't take sides. You have to call it the way the law requires, irrespective of how that means it will come out. Don't listen to what the first witness has to say about it and make your mind up. Listen to the first and then set it aside. Evaluate the testimony and then set that aside and listen to the next and the next and the next. But please don't make any final conclusions in your mind till you've heard all the evidence in the case, you've heard my instructions on the law, and you have retired to begin your deliberations. The rules of the court also require, and I don't make the rules, the Supreme Court does, they require that you not discuss the case at all among yourselves. I think one of the reasons for that rule is when you start talking about it, you start making up your mind about it, and they want to make sure you do not make your mind up until you have heard it all. And so please do not discuss the case among yourselves until such time as you've heard all the evidence, you've heard my instructions on the law, and you retire to begin your deliberations. Do not talk about it, don't form any opinions about it, and do not discuss it at all. Be mindful of my previous instructions to you. The defendant, Amanda Hayes, having been charged with murder in the first degree and accessory after the fact to murder in the first degree, and having entered pleas of not guilty, under our law is presumed to be innocent. She's not required to prove her innocence, and the fact she's been accused is no evidence whatsoever of any guilt. The state having caused the charge to be brought, the state has the sole responsibility of proving guilt if there be any, and the state must prove that to 12 of you, 12 original jurors, beyond a reasonable doubt. Ms. Hayes, being presumed innocent, has no obligation to prove or disprove anything in this courtroom. You have notepads. I suggest that you might want to take advantage of that. Some of you probably are note takers, and some of you probably aren't. But you might want to at least not jot down the name of a witness and anything that of significance you think they may have contributed that you might want to remember later. Don't get so caught up in taking notes that you miss something. Sometimes you can get so caught up in note taking that you miss something important. The fact that you write something down doesn't make it important. The fact that you didn't write something down doesn't make it important. Everything is important, and you will all individually and collectively remember all the evidence in the case at the time you deliberate in making your decision. I just want to remind you again, this entire proceeding is being recorded in the media. That's how the public has the right to know what's going on. As I told you earlier, 30 years ago, if you want to walk in the courthouse, sit down on the back row and see what's going on, people did. But now with so many busy lives, that the way they find out what's going on in their community and in their courthouse in cases in which they may have some interest is they turn on the computer, they turn on the TV and watch it just as you're watching it. I tell you that simply to let you know that these proceedings are open. Courts are always open for the public to know how the public's business is being conducted. But you need to be careful that you're not exposed to any of that information, because you have to try this case not on the comments or commentary of some newscaster, but based upon what you see in the courtroom. And therefore, please be careful not to watch anything on TV, don't listen to anything on the radio, don't see anything on your computer. You need to be able to isolate and insulate yourself from exposure to any kind of information being discussed or broadcast about the case. Again, don't go to any alleged crime scene. Don't do any research on your own. Don't get fascinated with some concept that's being discussed and think you need to go Google it and try to educate yourself about it. Don't do that. The rules of the court prohibit you from doing that. Don't do any kind of investigation. Don't read any law. All of you need to hear the same thing. You need to be exposed to only the same information. You need to apply the law that I give to you and not something that you read in a book somewhere. And therefore, the law requires that all of you make your decision based upon what you hear in this courtroom only, and the legal principles that I explain to you only, and therefore that you will collectively and individually make a decision that you find to be a just and fair result under the law and the evidence of this case. The court schedule will be basically, we'll start about 9:30. Please be here on time. If one of you's late, we can't start without you. And if something happens, please call Ms. Vann and let her know so we'll know what your situation is. We'll usually stop for lunch about 1 o'clock. We'll take an hour and 15 minutes or so for lunch. We'll probably stop about 5 o'clock in the afternoon. We may alter this slightly, but not much. We'll take a break in the morning for 15 minutes or so and in the afternoon, but that's going to be our court schedule most of the week. It's winter time. We may have bad weather. If we have bad weather, we will let you know how that impacts on you. So Ms. Vann will be calling you to tell you how bad weather may impact on the court schedule, and I will tell you if I can project far enough ahead of time. But we will keep you informed, and we're not going to ask you to be down here in dangerous conditions or anything like that. If you have some emergency, please call Nancy Vann and the number that she's given you to let us know what your emergency is, and we will adapt or adjust our situation accordingly. The attorneys are now entitled to make, also with regard to the media, please know and understand the rules of the court provide that the media cannot take your picture. No one is going to have, no juror's picture will ever be taken. These are professionals standing back in the back of the courtroom. They know what the rules are. They will not take your picture. In fact, they will make sure they don't. They'll do everything possible not to take your picture, but not to create the impression that your picture is being taken. So don't concern yourself about the fact that the camera's in the courtroom. Don't be distracted by it. Just don't consider it any further. The attorneys are entitled to make opening statements to you now. An opening statement is just that. It's a forecast of what they say, and they contend you're going to hear from their perspective. They're not witnesses. They're not presenting evidence. They're giving you a forecast of what they say the case is about from the perspective of the speaker. What the evidence in fact shows, what the case is in fact about, is for you, the jury, to say and determine, but to help you understand the perspective of both sides from the beginning of the lawsuit, the rules of the court allow the attorneys to make brief opening statements. Mr. Zelling, I believe you are going to speak on behalf of the state. The jury is with you, sir.